Welcome, everybody. My name is Linda Spiegel. I am the president of the Beverly Hills Bar Foundation, the charitable arm of the BHBA. Thank you for joining us for the 2020 U.S. Supreme Court nomination debate. Before you sign off at the end of the program, I want to encourage you to check the chat box for a link regarding the Beverly Hills Bar Association. And I am not broadcasting live from the U.S. Supreme Court, although I'm the blonde in the middle there. That was me taking a group of attorneys for admission to the U.S. Supreme Court. I'd like to introduce our illustrious speakers. First, Senator Byron Dorgan, Democrat. Senator Dorgan serves as the co-chair, along with Congressman Phil English, of Arent Fox Government Relations Practice. He's recognized as having substantial knowledge in the areas of energy, transportation, infrastructure, taxation, technology, defense, national security, trade, Indian affairs, and has been an author of major energy legislation, as well as transportation and tax policies. Representative Philip English is former U.S. Congressman, a senior government relations advisor, and co-chair, along with Senator Dorgan, of the government relations practice of Arent Fox. He currently serves as coordinator of the Healthcare Group Purchasing Industry Initiative, which enforces industry standards, promotes best practices, and monitors adherence to its ethics code by healthcare group purchasing organizations. The HGPII is an independent ethics oversight organization with responsibility for a major part of the healthcare supply chain. And our professor, Caroline Fredrickson. Caroline is a visiting professor at Georgetown Law. She's an author on legal and constitutional issues and is a frequent guest on television and radio, including serving as a regular on-air commentator on impeachment. From 2009 to 2019, she served as the president of the American Constitution Society, and she spoke on issues such as civil and human rights, judicial nominations, and the importance of courts in America, marriage equality, voting rights, the role of money in politics, labor law and anti-discrimination efforts, rule of law, congressional oversight, and separation of powers, among others. So as you can see, we have a panel that is well-versed, not only in politics, but in constitutional law. Let me begin by setting the table. President Trump has nominated Judge Amy Coney Barrett to replace the late Ruth Bader Ginsburg on the Supreme Court. We're less than a month away from the general election. For years, the Republicans have raised the issue of legislating from the Supreme Court bench, and a liberal one at that it was. Finally, the Republicans have the opportunity to regain a conservative supermajority, 6-3, on the highest court in the land. But under what circumstances and at what cost? I'd like to begin with Representative English, and the question will then bounce to Senator Dorgan. How will a confirmation so close to the election affect the political atmosphere in Congress and more broadly throughout the country? And what are the consequences of this nomination on future nominations on current elections?
I guess the short answer is, I think it has the potential to fire up Congress, fire up both bases, but to be candid with you, everything is so wildly polarized at this point. The real impact on the institution, more on that at a moment, but on the immediate political landscape is likely to be determined by how Judge Barrett is treated and presents herself at the Judiciary Committee. I believe potentially the American public may make a very different conclusion about Judge Barrett than a great deal of commentators already have. I believe that most people don't care so much about conservative supermajorities, all the more so because they tend to be fleeting as the issues change. My sense is that Judge Barrett has an opportunity to make an impression, and I think people will have a fresh chance to look at the Supreme Court and decide whether this is a big institutional change and what they want from here. I have no doubt with the changes in politics that this is going to energize both conservative and progressive networks. But again, I think they are already energized. What impact will it have on the institution long term? I think that depends on the agenda of issues that moves through the court over time. I think how judicial restraint is imposed is likely to have a big impact on the country, and also whether the Supreme Court is seen as an outlier or an institution that rises above politics. One of the sad things is that I've seen in my lifetime the whole process of approving judges as the Supreme Court itself has been buffeted by political winds as becoming far more politicized, far more polarized. More on that later. But I think it was inevitable that there would be a crunch point, it has come now, in which a Senate, and I'll turn this over to the senator in a second, but where the Senate increasingly has dealt with this issue in a polarized way. In this case, although this is an issue, an appointment coming in at the very end of a political season, this is a nominee who has already been fully vetted, who has been considered by the Senate before, who will have an opportunity to make the presentation. And I think there will be time between now and the end of this Congress for her nomination to be considered in the Senate. And I expect it to go through. I'll leave this to my other colleagues to comment.
Senator Dorgan, same questions.
Well, yeah, I mean, this is an intensely partisan proposition that's happening in our country. And in, let me just say that I personally voted on 5 Supreme Court nominations. The first nomination I voted on was Ruth Bader Ginsburg, which was the first nomination under President Clinton. These are lifetime appointments. You know, this is not some short-term deal. These are lifetime appointments. And the reason that this is so intensely partisan right now is not so much because of who is being nominated, although that will become, I think, very controversial and reasonably so. But we had a circumstance where in the last year of President Obama's term, 10 months before his term ended, there was a vacancy. And President Obama submitted a nomination for that vacancy, a very esteemed judge, circuit court judge, Merrick Garland. And Mitch McConnell said, Merrick Garland will not get a hearing. He will not get visits with me or many of my colleagues. We intend to do nothing to advance this cause. And he said, it's too close to an election. Senator Mitch McConnell said, let's let the people decide. It's only 10 months from now. And so he was saying, we're not going to do anything on this to advance the nominee that President Obama did or offered them. And so now Ruth Bader Ginsburg dies. She spent, as you know, her career working on gender equity and working for women's rights and so on. And now it's, 45 days before the election, and Senator McConnell decides, you know what we're going to do? We're going to run this through the next election. Let's not let the people decide this time. We don't care what the people say this time. We're going to run this nomination through. The result would be a 6-3 court. In my judgment, very partisan, very heavy to the right side. And I would say that I think much of what will come from all of this is threats to very substantial issues, Roe versus Wade, gender equity, climate, a whole series of things that I think are so important to the American people. So yes, this is going to be very controversial. Let me finally say the Republicans will be able to get this done if they have all their people and have their votes. I mean, they have the legal capability to get it done. It's not right, not fair. They know it. And let me mention, if I might read you just one more quote. The quarterback for this has been Lindsey Graham, the senator who's up for election in South Carolina at the moment. And Lindsey Graham said this. he will chair the hearings. He said this in 2016. He was not going to advance Merrick Garland because it was 10 months and then the people would be able to speak. So he said this: a Supreme Court nomination should never be filled during an election year. And you can use those words against me, he said. Well, he changed his mind and now he's going to chair the hearings. And I just think the American people look at that and say, what are you all doing? Can you tell us the truth about some things? These are lifetime appointments. You know, give us an opportunity to think through what these appointments will mean to life in the United States.
Okay, excellent responses. I will get to the 2016 procedural strangeness in a moment. But for right now, I want to ask Professor Fredrickson, the word that I'm hearing a lot right now is unprecedented. I don't know if it really is that unprecedented. I know that President Lincoln, the Republican President Lincoln, refused to put forth a nominee in his term, before his second term, because he wanted to wait until the elections. I don't know how unprecedented this is, but the question is, the law relies on precedents, stare decisis. So how will the acceleration of these hearings affect public perception of the U.S. Supreme Court?
Well, thank you for that question, and thanks for having me be a participant with such luminaries as co-panelists. I'm very appreciative. This is a very, very important moment for our country. Just as the law depends on precedent, I think Senator Dorgan can certainly speak to this with greater authority than I can. I did spend 10 years working in the Senate, but I was a staff person. But the Senate depends a huge amount on precedent as well. Although there are the rare examples that one can cite, it is fleetingly rare for a nominee to be considered so late in a president's term. So it is very unique. And I think because of the situation we're in as a nation right now, with a very fraught election, with hyperpartisanship, with a pandemic, with economic turmoil, with huge amounts of unemployment, with tensions over police violence and so forth. I think it just puts a spotlight on this as being yet another example of overreach and abusive actions by a minority group that doesn't want to allow for an election to have consequences potentially and have somebody else make a choice. So I think it's very, it puts the Supreme Court in the public eye in a political way that I find very unfortunate. That I think as over time in recent decades, the Supreme Court has gone from a highly trusted institution to one that is seen as just another partisan branch of government. I think that really disturbs us all. It disturbs our nation. It disturbs the law and the precedent that you had mentioned, that we all need to depend on a court that is bound by an understanding of how law is developed, how we have stability in our country by rule of law as a dominant force in a democratic society. So I think we are in a very unfortunate situation. The consequences are great. I think one of the things that troubles me the most is that in addition to, I think the very expedited time frame, which the average time for a consideration from nomination to confirmation is 70 days as opposed to the 40 or so that we're looking at here. So already it's a really accelerated timetable. But with some of the comments that have been made about needing to have a justice on the court to address cases that will be brought up to contest election results in order that one side might win, and I will just say it's the president's side since he's the one who said it. And I don't mean to be partisan here, but simply to say that suggesting that putting a justice on the court so that she can help decide cases in his favor aggravates that problem that we already have in our country of the Supreme Court being seen as, whether it is or not, and we could talk about that, but that's not so much what I'm focused on, is the perception which I think is incredibly destabilizing for rule of law in our country.
You almost took away one of my follow-up questions, but for the moment, let me return to Representative English. So, there's my dog. I apologize for my barking dog. Both Senator Dorgan and Professor Fredrickson have raised the issue of the 2016 irregularities, where a Democratic president nominated a nominee for the U.S. Supreme Court, and the Republicans at the time who held the majority in the Senate said, no, we're going to wait. Now tables have turned. So the question is, we have a Republican president, we have a Republican-held Senate. Is that justification enough? Just because you can, should you? Representative English.
That not only that, they should, because they actually have a mandate. Donald Trump ran on this in 2016 and was elected president. A majority of Republicans made front and center the idea of pursuing aggressively the right kind of judicial appointees. I think they would be hit by their base and also a broad range of voters for malpractice if they didn't move forward. Let's be very clear here. The precedent that Mr. McConnell put forward at the time in 2016 was that there was a difference between the mandate of the U.S. Senate, which was pretty solidly Republican at that point, and the mandate of the president, who had just lost an off-year election. What we have right now is the president's party and the Senate majority aligned. Why wouldn't they go forward? Is this in fact rushed? This is a highly vetted nominee, not to everybody's taste, although I think it's worth noting she is attracting support from colleagues who admire her scholarship across the judicial spectrum. I'd also point out that it's fair to say that there are some people who messaged something very different in 2016, including Lindsey Graham, and some of Mr. Trump's recent comments are difficult to figure out. As somebody who served with Lindsey Graham and likes him, I'm not surprised that he's guilty of a certain amount of imprecision. I think the broader point here is that this is a nomination that ought to be filled. Certainly there is an example, and if you dive into it, Mr. Lincoln was under some unique circumstances in not putting forward a nomination at that point. And I admire him for doing that. But if we're looking for other precedents, probably the most influential person who has ever served on the Supreme Court was John Marshall. He was appointed after the Federalist Party was beaten in the election, and he was cleared by the Senate in 1 week, because he was well known to them because he was Attorney General. I think what you are seeing, if you go back to the pre-Bork precedents, I think you'll find that in those days, judicial nominations, Supreme Court nominations were less controversial, and it was common that they happened much more quickly. As we have become bogged down, and I think Byron Dorgan is a great institutionalist and can defend the Senate to anyone's criticism. But I think it's fair to say that they have time to do it. I looked this up. Ginsburg was approved after nomination in 42 days. O'Connor was cleared after 33 days. Stevens in 12 days. And going back to the 1960s, it was fairly common for nominees to be put through on a voice vote. So it's there are a lot of precedents here, and I think what we're seeing is not one side overreaching so much as big changes in the institution. Now, there is a real issue here: does the fact that this has become so politicized on both sides ultimately detract from the institution? I think that's a problem, but frankly, it's not a new problem, and it's not new to this nomination. It's something that's going to be with us for a long time.
Senator Dorgan, you had mentioned fairness, and I want you to have a chance to respond to Representative English, and also expand on the issue of fairness in terms of moving the goalpost, as the situation seems fit.
Phil and I are good buddies. So he mentioned that Lindsey Graham had some imprecision, actually, as well. In fact, Lindsey actually did a little promo on the back of one of my book covers, one of my books. So Lindsey's a friend, but it's not been imprecision. He's been precise in his unfairness. And I accept that criticism, I think, because he's going to chair the hearings. But let me say this. I don't want to keep talking about Mitch McConnell, but I have to, because the symphony conductor on what's happening to the judiciary starts with Mitch McConnell and ends with him. He's a majority leader in the U.S. Senate for the Republicans. And I want to tell you, and Carolyn Fredrickson would have been in the Senate at this time. Mitch McConnell, after Obama was elected president, decided he was going to do something vastly different than had ever been done. He was going to go to the floor on every judgeship, every nomination. He was going to filibuster the motion to proceed. When you filibuster a motion to proceed, it'll take a week to get something to the Senate. He did that over and over and over and over again, and the Democrats couldn't get these judicial nominations completed. So Harry Reid did something that I didn't agree with at all. Harry Reid decided to eliminate the filibuster on federal court judges. He didn't include the Supreme Court, but he did it on federal court judges and nominations, and I would not have done it. Don't like that he did it, but he did it. And he did that in order to get federal judgeships through the Senate, get them nominated and approved. And then what happened when Trump was elected president, Mitch McConnell decided he would change the rules further, and he would make sure that a Supreme Court nomination would not have the filibuster. He changed the rules and eliminated that filibuster. And now you have 3 people joining the Supreme Court, in most cases by one vote for a lifetime appointment. And I want to say this about the court. I think someone who goes to the Supreme Court should represent a consensus, not one vote. They should represent a consensus of what the American people think we ought to put there for a lifetime. That's not been the case now. And so coming back to Senator McConnell, he's right where he's wanted to be. He did that to all the nominations during Obama. He prevented Obama from a 10-month nomination with Merrick Garland, an unbelievably distinguished judge. Republicans and Democrats understand that, but he captured that judgeship and wouldn't hold a hearing. And then now with 45 days, Ruth Bader Ginsburg, this remarkable justice, dies, and now they say, we want to move ahead, and we don't care so much what the American people think next 45 days from now. We're going to do what we're going to do. They have a legal right to do that. I don't know how they explain it. I don't know how they explain the unfairness of what they're doing to the American people. And at the end of the day, you'll have a 6-3 court, heavily tilted toward the right, unbelievably conservative in my judgment, and considered much more political and partisan. And I think that's a terrible tragedy for the reputation of the Supreme Court.
And to give us an idea of what cases exactly the court might face this coming term and for the foreseeable future, Professor Fredrickson, can you give us an overview of the cases that we anticipate will be coming before the court and what this change in dynamics may mean for the Supreme Court?
Well, I'll just mention a couple. There's another religious liberty, so-called religious liberty case coming before the court, which deals with the City of Philadelphia and foster care program. The City of Philadelphia has a non-discrimination policy that requirement in its contracting, and it gives grants out to different organizations to administer foster care. A Catholic charitable organization has challenged the denial of contract to engage in foster care because the city has required that they allow same-sex couples to also be foster parents. And so it poses a rather unique question about whether a city could be forced in some ways to develop contracting a regime that forces them to consider discrimination by certain of the contractees as something that's allowed. So that's a significant case. There are a number of other issues. There's one involving the definition of a seizure under the Fourth Amendment, which is a kind of unique case where a woman was outside of a housing project and was in her car, was approached by some police officers who were not wearing uniforms and apparently did not identify themselves to her. And they wanted her to get out of her car. She refused because she thought she was being carjacked. And so as she was driving away, she was shot. It's a horrible case. She survived, but the question is, and it's really quite, very much of a question of this moment. The question is that if she ended up getting away, and the question posed, is that a seizure under the Fourth Amendment if she doesn't actually get held by the cops? So she's suing for liability. So it's at a time when the Supreme Court had decided the last term, a lot of people thought they would look at the qualified immunity issue for police officers. They ended up declining that. This is one that presents another, and it's a very, the statistic or the story is quite heartbreaking. But I think what we're all focused on probably that is going to be the most earth-shattering potentially, although I hope not, is the potential for another Bush v. Gore. Again, to go back to the issue of the sort of the status of the Supreme Court as an impartial arbiter, it was already so profoundly shaken by what was perceived as a very partisan decision in Bush v. Gore. And the idea that it would, first of all, that President Trump has made those statements repeatedly about needing Amy Coney Barrett on the court to be able to decide cases in his favor, that if that were to happen after she was appointed and a case presents itself that looked like to the American people, they think they have supported Joe Biden for president, and in fact, the court then issues a decision that looks like it's handing the presidency yet again to a Republican president, with the addition of a rushed nominee that the President Trump has said is going to be there to decide any cases in his favor. I think would be the, if not the end, it would be very close to the end of the Supreme Court's status in American society as above partisanship, above polarization, and would be seen as not only part of it, but also a precipitator of an increased dangerous amount of polarization in our society. And I think for our democracy, I very much hope that on election night, we see a very decisive win one way or the other. I mean, you probably can tell which way I would prefer, but I want either way there to be such a decisive win that we don't have one of them challenging mail-in ballots that have been part of our election system for very long and have an incredibly low level of inaccuracy or fraudulent measures associated with it, that we don't have that kind of attack on our election system, but that we really have a decisive outcome fairly quickly, if not on election night, then several days afterwards, and we can pull through this with a democracy that is secure, with faith in our court that is not going to be so shaken by what seems to be a very partisan decision. That is, I think, what most people are sort of thinking, that if the court decides any blockbuster case this term, it could be something to do with our democracy. And I think we'd all prefer that doesn't happen.
I'm going to follow up on that train of thought in a minute, but for now, I want to bring back the Judiciary Committee's rules. Currently, there are quorum rules, and one of them requires at least 2 members of the minority be present. We know that the Senate has the ability to change those rules. Representative English, what modifications to the rules do you expect might come from the Senate Judiciary Committee's chair? If members are unable to attend in person because of the current COVID infection, and what changes do you think they might want to take in order to move the nomination quickly along?
I think we've seen a pattern on the Hill that since COVID, there is likely to be an opportunity to participate remotely. Certainly, there's ample precedent for that. My sense is, in terms of minority participation, I don't want to get too far over my skis in predicting what is going to happen that might be horrible. I do think there is a chance in an extreme position that perhaps the nomination could be discharged from the Senate, but from the Senate Judiciary Committee. But to be candid with you, I don't even want to explore that. I have to believe in the end that the process is going to work through, albeit on what some are calling an expedited timetable, and certainly compared to recent nominations, it is moving fast. I don't want to assume that the committee's rules are going to be altered in a way that creates a new set of problems. We've had some crises at different points in our lifetimes, including the Clarence Thomas nomination, where Joe Biden presided over hearings for which there was some subsequent criticism, but I want to make it very clear to you, I'm not sure it could have been handled much more fairly, and I thought both sides needed to be heard. If there is a controversy about Amy Coney Barrett, I think that the fast movement on this nomination may have to be slowed down. And I have to believe that the Senate, now that the president has made the nomination, the Senate will make an effort to do this in a way that aligns with its procedures. But I'll leave it to a former Senate staffer and a former leading senator to make a deeper dive than that.
Senator Dorgan, what response do you expect will come from the Senate Judiciary Committee minority members if the rules are changed? And do you expect them to be changed, or what do you predict may happen going forward, and what should happen?
Well, the short answer to that is I don't know what will happen. Senator Schumer has, he has written to Senator McConnell saying what I think should be the circumstances with respect to COVID testing and a wide range of things going into these committee meetings. And so I don't know. My expectation is that the chairman of the Judiciary Committee has the power to do what pretty much he chooses he wants to do. He'll have the votes probably to do that. And ultimately, I assume, unless they are interrupted by additional COVID infections, and none of us want that to happen, but there's on Capitol Hill and in the White House, we see daily now a fairly large number of officials who said they have contacted COVID. So we'll see what happens. I think it's not going to be as easy as they think to get the committee together and hold hearings as consistently as they'd like to, but these hearings should be lengthy. They should be extensive. Again, it's a lifetime appointment. This is a woman who likely will serve for the next 30 or 35 years on the Supreme Court and cast votes affecting American people's lives. And these votes will be about the Affordable Care Act, about guns, about immigration, about Roe v. Wade. It'll be about gay marriage, environmental protection, workers' rights, women's rights. So, I'd like them to get this right and have a full understanding of exactly what it is, who it is that we're putting on the Supreme Court.
Thank you. Okay, I'm going to pose this question to all three of you. I can start with Professor Fredrickson, but if, Professor, you would like somebody else to start, please let me know. Assuming some Senate Judiciary members are still contagious or not out of quarantine when the hearings begin, how does the inability to be in the same room and be face-to-face with the nominee affect the process?
Well, I mean, I do think it affects it greatly. The interaction, I mean, I think, everybody who's listening, I would assume is a lawyer and have been in a courtroom or been in depositions, been in arbitrations, been in different settings where you're actually confronting somebody face to face. And it's a very different dynamic. I mean, here we are on Zoom. I can tell you, I've done a lot of panel discussions in my life. And as much as it's a pleasure to be here with Congressman English and Senator Dorgan and you, it's such a different thing to be in a room with people and an audience and have live people asking questions. We all know that's true, right? So just imagine the stakes, as Senator Dorgan has said, are so high for our country that we get this right. And although she has been confirmed to the Seventh Circuit is not the Supreme Court. And in any case, there are new documents that have been coming out that have not been considered and were not part of her package of documents that was presented before. This really needs to have some extensive period of time for her to be reviewed. And I think it's very unfortunate that we've had that people are feeling pressured to put their health at risk in order to have that kind of experience, and that the senators who are contagious have been in and around the Senate and meeting with people. I think it's just, if Mitch McConnell, if the leader felt that it was appropriate to close the Senate down for a couple of weeks for business on the Senate floor because of the dangers of the pandemic, it could not be more clear that when you have two members of the Judiciary Committee who are contagious themselves, and people have met with Judge Barrett, who was at that ceremony at the White House, where now we've seen a cascading number of people come down with, or at least be tested positive. What could be more important than just waiting until after the election to move forward? I think we should wait until the next president has been chosen and have that president be the one make the nomination. But regardless, people should not be forced to have a sterile and less than satisfactory hearing that might have to be virtual for a lot of members, or choose to put their health at risk.
Senator Dorgan, same question.
Yeah, well, I mean, I largely agree with that. I think it is. I think it's hard. I served 18 years in the United States Senate, served 12 years in the House. Before that, I think being in a hearing and sitting across the room and looking in the eyes and seeing the reactions of witnesses and so on is so different, just vastly different than doing it virtually. And so, no, I especially for a lifetime appointment at the Supreme Court, would it be much, much, much better to have a hearing in which you have everyone present and you're actually meeting the candidate, the nominee? I just think that is really important. Let me mention one other thing too, and I'll say it before Phil jumps in here. For the attorneys who are on the line, I described the history with respect to Mitch McConnell, Senator McConnell. You all should understand that while I'm critical of him, obviously, but he wouldn't mind that a bit because he boasts about what he's done with respect to judgeships. He openly boasts about that and thinks that's one of the most significant things he's done as a Democratic leader of the Senate. So he will not mind if I describe accurately what he has done. But I think this situation is, especially someone who has voted on 5 of the current 8 members of the Supreme Court and met with every one of them. I mean, obviously, I met with Chief Justice Roberts twice. He came in, we had lengthy discussions, and eventually voted for him. I was happy to do that. You learn a lot by meeting with people and being across the table at a hearing room from someone. You understand more than the opportunity to have some sort of virtual presentation. So Phil may have a different idea on some of that as well, but I think he would probably agree particularly in hearings in the Congress, it is beneficial for us to sit across the dais from witnesses and understand what that witness means.
It's beneficial under the circumstances. It's not indispensable. I think not only can you have safe procedures and social distancing, you can have an opportunity for individual members to meet with the nominee. I think in the end, you can get all of the input that you need out of the arrangements that can be made for these hearings. I do think that the chairman should bend over backwards to give all of the members of the Senate an opportunity to meet with the nominee, and if that slows things down, so be it. But I will tell you this: I believe that government still has to go forward, even for a lifetime appointment, notwithstanding having a pandemic going on. We may have a pandemic with us for many, many months, and that by itself shouldn't slow things down. Now, of the three of us on this panel, I make no pretense of predicting what is going to happen or what the potential dangers are from the appointment of Amy Coney Barrett. I think history tells us that Supreme Court nominations can produce very unpredictable results. I recognize her as a very strong conservative, but I also think that she is, by the testimony of her peer group, I think that she is highly qualified. She has exceptional skills and scholarship, and I really think there's a compelling argument to be made to go forward, not because of what might be going on with the election. And let me be very clear about that. I think that having lived through the 2000 presidential election, I think it would be helpful if this doesn't go to the Supreme Court. But things are so polarized that I think the Supreme Court is likely to be the least important factor in the fight that will undoubtedly succeed this election. And yes, this feels like it could lead to national divisions that are perhaps the deepest that we've had since the election of 1860. This is a danger point, but I don't think filling realistically this nomination right now is the main touch point in that problem. There are so many bigger factors. That's just my observation.
Linda,
Fair enough.
Can I just make a point about timing here? My understanding is, and maybe Carolyn can respond to it, my understanding is that a Supreme Court justice may not engage in a vote or not cast a vote on a case unless they were involved or unless they were a justice at the time there were oral arguments. And my understanding is that on November 10th, the Affordable Care Act is before the Supreme Court. And so my understanding further is that there are some who very much want to make sure that she will be at that November 10th, those oral arguments. And, this nominee has already spoken in a way that is not complimentary to the Affordable Care Act. But I voted for the Affordable Care Act, felt very strongly about it, don't want it to be abolished, and think that tens and tens of millions of people will lose their insurance if it is. So far, it has survived 10 years or 11 years, including court challenges. But we'll see. This November 10th date is an important date, I think, at least in the minds of some, so that this candidate, this current nominee, might be able to be involved in the decision.
Before you answer that, I want that dovetailed perfectly into my next question. So I'm going to ask the professor to answer that along with this question, which is, what duty would a newly confirmed Justice Barrett have to recuse herself from upcoming hearings? And does the rush to confirm a partisan appointment almost require that if she does recuse herself, she must tread light, if she doesn't, recuse herself in any of the cases that would come before her that either she wasn't a part of the deliberations or didn't come to a hearing while she was on the bench, or particularly for a presidential election decision? If she does not recuse herself, how much does she need to tread lightly in the event there is a presidential challenge?
Well, I mean, one of the unfortunate things about the Supreme Court, which I think many commentators and scholars now recognize is due for some major reforms, is that there are very few rules that really apply to it, and in fact, they set them themselves. And in terms of recusal, it's pretty much up to the justice. And so, I think this is a very important question for people to consider: is that she should recuse herself in cases that are presented in the way that you describe, but will she? And the court itself has not set, and maybe this is something I think that the Congress should take up, rules that are actually mandate them to recuse in certain cases. For example, we've had a number of justices, and this is not just conservative justices, it's both liberal and conservative justices who've heard cases in which had, with companies in front of them in which they had a financial interest. It's incredibly demoralizing to find out something like that. Again, to go back to the status of the court. So for Judge Barrett, I think, we are at a moment where, and I know I keep saying this, but I may be the Cassandra of this panel. I do think the Supreme Court is at a tipping point in terms of where it stands in American society, whether it can sustain a status of a body that is in any way above the nasty partisanship and polarization that is affecting American politics right now. For it to lose the last vestige of its higher status because Judge Barrett doesn't recuse herself in key cases that affect certainly the outcome of the election. And as I said, I think it will be about the last straw, and the Supreme Court will no longer be seen as in any way a gatekeeper for rule of law or our democracy.
Okay, thank you. Representative English, what do you think might be the motivation for Republican Senators Murkowski and Collins to announce that they would not vote for Judge Coney Barrett before the election? What would be any senator's motivation to do so?
I know Senator Collins very well. I've met Senator Murkowski. I think their motivation is that they are independent and they're taking a position which is perfectly defensible, even if I don't happen to share it. I think also that we do have a few people left in the Senate, including Susan Collins, who are independent thinkers and independent voices. Although I don't think Susan Collins now is being given credit for that. On the recusal thing, if I could just bounce back for a moment, that's a perfectly legitimate question to ask Amy Coney Barrett in hearings. And so I suspect that ought to be worked through. And I think conflicts of interest, given that Byron and I work on a major ethics organization for the healthcare supply chain, we take those things seriously. And I think the Supreme Court and the Congress ought to have the highest possible standards applied to them. I have to say, I think that, I think that this is not an inevitable approval because I think there are a lot of questions to be asked and some new material to be reviewed, although I continue to believe that given the month that they have to work with, and given that this is a person who has been thoroughly vetted before and is of certainly qualifications that recommend her for the position, I think that this process has the potential to be seen by the American people, if not by the political class, as legitimate. I think it's all going to come down to how people react to her as they are exposed to her. I hope that's helpful.
Yes, thank you. Senator Dorgan, before I ask the last question that I have, I want to invite our audience. If any of you would like to ask any questions that I haven't already or that our speakers haven't already addressed, please send those in now. We are close to the end, but not quite there. Senator Dorgan, and I'm going to ask Senator English, Representative English, the same question. Senator Dorgan, imagine that we have a Democrat in the White House and we had a Democratic controlled Senate. And we had the same situation. We had the ability to either confirm a nominee early that was of our party or to wait until the American people had a chance to decide the next election who they wanted in their Congress and in their White House. What do you think would happen? I know I'm asking you to predict. And what do you think should happen? And feel free to riff. Oh, you're muted.
Are you asking that if the tables were turned, we would do what the Republicans are doing? I mean, you know, I guess my feeling, I mean, I was elected statewide 9 times in North Dakota. I'm a Democrat. It's a Republican state. And I would not want, at least my own view is I would not want to go back home in North Dakota and say, you know, I know here's what I told you before, but here's what I say now. You know, what I told you before doesn't count. And so I would not want to be somebody who's having to explain that. Let's wait until the next election. Let the American people decide. That's what they said over and over and over again. Now they say it doesn't matter. Just doesn't matter. I want to come back to one other point, if I might, and that is the question of meeting with candidates, nominees for the Supreme Court. When a nominee is announced by a president, I hope that every U.S. senator will meet with that nominee. Now, in fact, there have been a couple of Democrats say they wouldn't meet with this nominee. I don't agree with that at all. If I were in the Senate, I would meet with that nominee. I would meet with any nominee for the Supreme Court. Now, I just think it's really important, and I would say to Congress, I think what's going to happen here is there's not a ghost of a chance that even a minority or majority rather of the United States senators will spend personal time meeting with a nominee for someone who's going to go to the court for a lifetime. I don't think there's a ghost of a chance of that happening. We're in the middle of a COVID attack, and there's just so many things going on here that suggest that the rush to get this nomination through, even while most senators will not have met personally with this nominee, the rush to get it through is paramount. And so let's go. Let's continue. I just look. I'm not someone who was very partisan when I was in the Senate. I think I worked with Republicans and Democrats. I don't think anybody believed that I was a partisan voice. The only reason I sound a little partisan right now in describing what Senator McConnell has done, and he's boasting about what he's done, so he doesn't mind my describing it, is I just think it is unfair. It is unfair. They took a nominee that should be on the Supreme Court that belonged to President Obama, and they made it a nominee for President Trump later. And now they're going to do another one with 45 days and rush it through in cases where most senators will not have visited, will not have had discussions with this nominee. So that, you know, and one final point, there is no question who are nominated for the Supreme Court in most cases, by all accounts, are really remarkable people. They're very skilled, well-educated, great experience. Now, that doesn't mean that they're all entitled to be, you know, putting on a robe for the Supreme Court. But I want to say that because I'm not suggesting that this nominee isn't a remarkable person. She isn't someone that I would prefer not be wearing a robe on the Supreme Court. But, you know, that's me. That's not Mitch McConnell or others. So that's my riff, Linda. And it's been an interesting discussion we've had, and I've appreciated being part of it.
Excellent. Thank you. Okay. Last question before I ask for final remarks from everybody. Representative English, let's assume, as I suggested, that we had a Democrat in the White House and a Democratic Senate majority, and there was a nominee available to put on the U.S. Supreme Court. What do you think would happen, and what do you think should happen, given that we're in a pandemic, and if we weren't?
I think the nomination would be made and would be passed by the Senate, and that's what should happen. I will tell you, there clearly, and this does not apply to Byron Dorgan, but there are clearly a lot of changing attitudes depending on which side you're on and the fact situation. That has been a problem as this process has been politicized, and other things like impeachment have been politicized, and there's plenty of blame to go around on that. I think, by the way, that Republicans should have met with Merrick Garland. I understand why, and they did not move his nomination forward, and I think that they should have paid a price for it and should have been forced to explain it. And now that their messaging at the time doesn't align with what they're doing right now, they should pay a price for it. Although I have to admit, I go back to Ralph Waldo Emerson, a foolish consistency is the hobgoblin of little minds, adored by little statesmen and philosophers and divines. And I think a little inconsistency in this space is probably not hypocrisy, although I think folks should be forced to explain it back home. And I doubt that they would do it as well as Byron Dorgan did in North Dakota.
Very nicely said. Okay, we have two questions, and both of them are concerning the justices on the court. So I'm going to direct them to Professor Fredrickson before she has to say goodbye to us at 4 p.m. exactly. Chief Justice Roberts has made it clear that he wants the Supreme Court to take a less political role. Is he a lone voice on the court and in Congress? Well, I don't know if he has a voice in Congress, or are others worried about this issue?
Well, I can't really get into the mind of the Chief Justice. I don't know that he has certainly tried to make people believe that he is very concerned about the reputation of the court. There are a few decisions that he is instrumentally involved in that I think have been rather challenging to that. The Shelby County decision, the gerrymandering decision, and Citizens United, which have been very detrimental to our democracy. But I would say I think that the other question is also extremely illuminating, because in the last election year that we faced this, when the Supreme Court was down one justice, somehow it was just fine that in an election year the court could be split 4-4. Now it's imperative that the court have the additional seat filled, at an expedited fashion. So I think the question answers itself, really, that opportunism is the name of the game. And I actually think hypocrisy is a much more direct way. And Ralph Waldo Emerson may have been a poet, so maybe he can't speak to politics as well. Hypocrisy just, I think, is the word that we would actually have to choose for this situation.
And one last question specifically to the court, and I know you have to leave, so I want to get your take on it. If a justice is allowed to recuse herself from sitting on a particular case, thereby reducing the decision-making Supreme Court body to 8, why is it? You just answered this.
Sorry, I looked at the chat.
Other people have thought the same. Okay, I'm going to direct this to all three of you. And Professor Fredrickson, if you need to drop off in the middle before I finish this question, I want to thank you so very much for taking the time. I know it was short notice, and it was truly a pleasure to have your take on it, given all of your experience and your background.
Such a pleasure to be on. Thank you.
Thank you. Okay, last question. I'll go to Professor Fredrickson first, and then to our other speakers. What are all of your thoughts on a potential court expansion? Professor Fredrickson, you can tell us yours first.
Well, I'll only say a couple of things. One is that I think it's just, for the lawyers in the room who haven't gone back necessarily to look at the Article 3 very recently, it bears noting, and it's good to tell people that who aren't lawyers, who don't spend their time reading the Constitution all the time, that there's nothing in the Constitution about the size of the court, and it has changed size many times in its history. And so whether people think it's a good idea or a bad idea, it's not an idea that is difficult to achieve. Congress can do that. It can expand the size of the court. It actually could reduce the size of the court too. It could get rid of 3 seats, which would be a kind of much more, nobody talks about that, but that would change the dynamic pretty much. It can also change the jurisdiction of the court and make it harder for the court to, or remove consideration of certain kinds of cases. So pretty much everything about what the cases are that the court hears and the size of the court are left to Congress to determine. So I personally actually think there are a lot of reasons to look at term limits for the court, which I think is a preferable reform in many ways to expansion. But I do understand the arguments for expansion, and I'm not necessarily opposed, but I do favor the 18-year approach, because I think that actually 18-year term limits actually would reduce a lot of the polarization, a lot of the political nature of the court. So, and I do apologize. I have many a Zoom in my life right now. So I'm going to sign off and say thanks to all of you, and thanks to wonderful Beverly Hills Bar Association and Linda for being such a great moderator. And to Senator Dorgan, thank you for being a great senator. I was, working for one of the other Dakotans at the time. I really had a chance to work closely with your staff on a variety of things. And thank you to Congressman English for offering your thoughts in this panel. And anyway, everybody, I hope that things aren't too smoky out there.
Thank you.
Anyway,
thank you so much for fitting us in among your Zoom obligations. It was a pleasure.
Absolutely.
Please join us
My
again
pleasure.
next time. Thank you so much.
Okay.
Okay, so let me pose the same question to Senator Dorgan. What is your thought on either expansion or term limits for the court?
Well, I have said that I think packing the courts, quote unquote, or unpacking, has happened, because I think they're being packed at the moment by taking one of Obama's nominees and turning it into a Trump nominee. But having said all that, there will be a big discussion about expanding the court. I don't think it'll happen, honestly. It'll be part of the noise of democracy, perhaps, but I don't think it's going to happen. I do support term limits, the 18-year that has been discussed. I think it would be really important to do something like that. I talked about that 15, 20 years ago, but it generally doesn't go anywhere. Let me just say this, and I know you've got a lot of people listening in and watching. It's the question is, what does American citizenship mean to all of us and to each of us? And one of the things it means, as it said, this noise of democracy that we hear, some of which is not very pleasant, others of which is really important in terms of how we live our lives. I think the ability for us, all of us individually, with the power of one and the power of groups, to decide what kind of a government we want to have is unbelievable. It's one of those remarkable things given us as citizens to decide what our government is and who it is. And that happens November 3rd. And so, there's going to be a lot happening between now and then. And we're going to see just a lot of noise. But look, on the day of the election, November 3rd, and between now and then when others are casting their votes, too many people, about half the American people by and large, have decided not to participate in the good elections. This time it's really important. What kind of government do we want? How will it affect our lives? What is the circumstance of American citizenship that gives us the right, the power of one? So I hope everybody does that and understands the importance of doing that and casting that vote on November 3rd.
Well said. Representative English, you get the last word on expansion and or term limits.
And I'll associate myself with Byron's last comments. Term limits, terrible idea. I do support term limits for members of Congress to ensure a regular inflow of new ideas into the political arena. But it seems to me with the Supreme Court, you need to have a certain institutional memory. And I would have hated to have seen term limits applied to William O. Douglas, whom I don't necessarily agree with philosophically. And I would have hated to see term limits applied to John Marshall and a variety of others who set the character of the court at critical times. I think that court packing, and there's no other way to put it, court packing by adding a few seats would be a bigger disaster for the court in terms of its political standing than virtually anything we've discussed here. I'm not a student of the Constitution to the extent perhaps that the professor was, but I am a little bit of a student of history, and I had the privilege of serving on the FDR Commission when they put together the monument. I'm familiar with FDR, and I saw how in his moment of overreach in 1937, he tried to put new seats on the court to compensate for any member of the court who was over 70 years old. It caused a massive backlash. I'm not sure it would today, but my instinct is that people would rally behind retaining the court at its current size, a position that, at least in one comment, Ruth Bader Ginsburg took. I think it would be a terrible mistake for court packing to be seriously proposed. I think there will be terrible pressure if you have a Democratic president and a Democratic Congress. There will be a major part of the Democratic coalition on the left that will push for that. And I think if that is the case, I think there will be a great deal of pressure on the Democratic leadership to try to manage that issue, because I do think it would blow up. I think it would be seen as a watering down of the independence of our judiciary at a very, very critical time. And that's even acknowledging some of the arguments that Byron has made here today about how there has been an enormous growth of Republican and conservative judges in the federal judiciary. The beauty of all of it, and I'll leave you with this, is in the end, there can be a lot of judges appointed, but judges who are given a lifetime appointment sometimes do the strangest and most independent thing. So I don't really want to predict what's going to happen in the immediate future. And maybe the bigger issues are going to be those beyond the immediate court issues, things like the constitutionality of a wealth tax, which could be a very, very important decision by a future court, particularly if there's a progressive Congress. Thanks for listening, and thanks for having us on.
Linda, might I just say that Ruth Bader Ginsburg, to come off of what Phil just said, Ruth Bader Ginsburg observed that she would be satisfied with the Supreme Court when it had 9 women.
Very, very good quote from her. Thank you. So I would like to take this opportunity to say, if the two of you would consider or could run again, our Congress and our country would be so much better for it. You are excellent representatives of what it means to be an American and a politician in our country. I want to thank you so much on short notice for joining us. Your comments were extremely illuminating and gave a good balanced approach to what everybody should be thinking about when it comes to this nomination and the election. I want to echo Senator Dorgan's comments about go vote, regardless of whom and for what. Go vote, cast your ballot. It's extremely important, and our country depends upon it. And lastly, for all of you who are still watching, please stay tuned, because we have a short video for the Beverly Hills Bar Association, and which has brought us this opportunity. There will be YouTube replays, so please watch out for those. And good health to all of you. Take good care. And we hope one day you'll take our invitation again. And thanks to Arent Fox for lending you to us today.
Thank you, Linda.
Thank you.
Thanks so much.